Trump breaking news. Supreme Court to hear Trump's Colorado ballot case. Know what? Key information.u.s. Supreme Court justices will decide whether former President Donald Trump may be removed off the Colorado ballot due to his claimed involvement in the U.S. Capitol riots that occurred on January 6, 2021, even if he is the leading candidate for the Republican presidential nomination in 2024. The 14th Amendment, which includes a clause pertaining to the American Civil War, will be the subject of oral arguments this coming Thursday. Not only might a Supreme Court decision affect Trump's chances of re-election, but it may also affect how states interpret language, which could prevent him from being on the ballot later this year in some instances. At Thursday's oral arguments, the 2024 presidential candidate's wealth will be highlighted. The focus will be on the rarely discussed Section 3 of the 14th Amendment, sometimes called the Insurrection Clause, which could have huge stakes for Trump in the event that the court rules against him, according to George F. Will, a political contributor for News Nation. It would be landmark if the court allowed states to remove a candidate from the ballot who received 74 million votes in 2020 and is now ahead of the current president in national surveys. That would set off a chain reaction, causing this nation to experience turmoil not witnessed since the 1850s. Will added, the Insurrection Clause, what does it say? The 14th Amendment's Section 3 prohibits engaged in insurrection or rebellion or given aid or comfort to the enemies thereof from holding any office, including that of president or vice president. It just takes a vote of 2/3 of the House or Senate to nullify Section 3. Along with Section 3, the amendment was the Post-Civil War Act that granted citizenship to individuals who had been enslaved. In what ways is an amendment that was passed during the Civil War relevant modern day? Following the Capitol riots on January 6, 2021, the provision made its initial reappearance. Representative Marjorie Taylor Greene, Republican Georgia, and New Mexico County Commissioner Couy Griffin were among the lawmakers that came under fire after a failed attempt to overturn Greene's conviction. The Supreme Court will later this month consider a case challenging Griffin's conviction from a lower court. The fact that Trump is actively seeking the presidency, though, elevates his case to a new level. In light of Trump's suspected involvement in the disturbances that occurred on January 6, the Colorado Supreme Court determined that Section 3 could be utilized to exclude him from the primary ballot. A comparison of the presidential track records of Biden and Trump on policy. The conservative-leaning Supreme Court, which includes 3 justices selected by Trump, has taken up the case against the Colorado court's decision, and the Trump campaign has taken it there. Will counter that the justices' political views will be zero factor in their decisions. Can you tell me Trump's argument? In an effort to terminate ballot challenges quickly and decisively, Trump's legal team has urged the court to do just that. Legal documents submitted by Trump's team warn that the removal of his name on state ballots would cause chaos and bedlam and would disenfranchise millions of Americans. On Monday, Trump's legal team criticized the Colorado verdict as anti-democratic in a filing to the Supreme Court. They also noted that Trump is the leading candidate for President of the United States. According to Trump's camp, Section 3 can only be enforced through a congressional act and only prevents anybody found to have violated the amendment from holding office, not from being allowed to cast a ballot. On top of that, they claim that Trump did not spark a rebellion on January 6. The conservative lawyer and Trump detractor George Conway characterized the filing on X, formerly Twitter, as bizarre and a sign of weakness. Law scholar Lee Kowarski of the University of Texas called the Monday petition by Trump's attorneys a massive tactical blunder. Would this prevent Trump from being on the ballot for the main election? Will avoid making a decision that could be perceived as having political implications? Many analysts predict the Supreme Court will refer the case to Congress, because, according to Will, Congress will never do anything. This may put off the ballot struggle forever, so diffusing the situation. The potential reaction of the country in the event that Trump is removed from the ballot has been considered by certain legal scholars. According to Rachel Kleinfeld, who spoke with Politico, there are worries that a court decision against Trump might catapult the country back to the level of violence seen on January 6. This idea, however, is incorrect in the opinion of Kleinfeld, a senior scholar at the Carnegie Endowment for International Peace, in an interview with Politico, University of California Davis law professor Andrew Tang said that a Supreme Court verdict against Trump would come with great risk and great reward for the country and the court. This is in contrast to Nikki Haley's stance on voter-relevant matters. Tang stated in Politico that the public's perception of the Supreme Court's legitimacy could be boosted by its rulings. Tang expressed concern that the court would feel emboldened to further shift the law toward the right on power-key topics like as gun control, abortion, voting rights, and others, and that this legitimacy could have long-term consequences for moderates and Democrats. At this point, what does the Trump Colorado case stand? If the court follows through on its promise to move quickly, the Associated Press reports that the time it takes to receive written papers and hold arguments in court could be drastically reduced. The way the court defines insurrection, which it has the authority to defer to Congress, will likely determine the case's trajectory, according to Will. Caroline Fredrickson, a law professor at Georgetown University, stated on NewsNation's Morning in America that the justices could decide to let the states decide whether Trump should be included on their primary ballots, even if they could rule on the language in Section 3. Fact that Trump is free of criminal charges related to the riots of January 6, she argued, should be significant. But according to Fredrickson, it could be influenced by the January 6 committee's conclusions regarding Trump's role in instructing his followers to fight like hell and take the country back. In his remarks, Fredrickson framed the matter as one of civil rights and democratic principles concerning the eligibility of candidates for the nation's top office. No prior criminal record is necessary. Not even a criminal complaint is necessary. However, we have the evidence necessary to prove that someone had taken part in the rebellion or helped to ease its distress. Trump case has additional legal ramifications. Maine is among the states contesting Trump's ballot appearance, even though the Supreme Court issue is directly related to Colorado, while similar challenges have been successfully defeated in states such as Michigan, Illinois, and Minnesota. A victory for Trump would pave the way for the ex-president to be included on statewide ballots across the country. Dementia and nose-picking, a case report aside from the lawsuit before the Supreme Court, for separate criminal investigations have filed 91 felony accusations against Trump. In 2 of these instances, the ex-president is said to have attempted to reverse the 2020 election results. On Tuesday, a federal appeals court rejected Trump's assertions that he is exempt from prosecution and stated that he may face conviction.